Good morning again. My name is Oren Bar-Gill, and I'll be moderating this second panel titled Privacy Compliance Regulation versus Market Forces. I'll just take just a couple of minutes to introduce the session and the panelists, and then leave it to the speakers. So as we know, and has been introduced to us already, privacy is a major issue and topic for regulation and policymaking, many debates over how best to regulate privacy. This session in particular is going to focus on what firms do and how firms think about privacy. Are firms protecting the privacy of their customers? How are they protecting the privacy of their customers? What are they doing about data security? And in particular, what motivates firms in their privacy or data security related decisions? Are they driven by market forces? And we've already seen from the former panel that if market forces are produced or generated by consumer preferences, then there is kind of a big problem, or at least a big question mark about how these market forces might work. Are firms motivated by regulation, by the threat of regulation, but what lawmakers might do, enforcement actions that might be taken? Another question here, moving more to the law and policy dimension, is what is the law doing in order to induce firms to protect privacy? Is the law doing a good job? Should it do anything differently? Do we want very strict rules and strict enforcement of privacy policies or privacy regulations, or do we want to leave this at a more kind of softer guidance level, let the industry develop norms and figure out how best to protect consumers' privacy? So these are some of the questions that our panelists are going to address. Florencia Marotta-Wurgler is going to focus her discussion and presentation on privacy policies, the very common privacy policies that firms offer, and we'll try to see what's in those privacy policies, what are firms thinking when they're designing these privacy policies, some wonderful noise in the background, and whether firms are, in the design of their privacy policies, whether they are motivated by a threat of regulation, by market forces, or by other things. Deirdre Mulligan is going to then talk to us about the institutionalization of privacy protection. She will be focusing on kind of the internal workings of firms. What are they thinking? What has motivated them organizationally, institutionally, kind of norms in the industry, and so forth. Let me briefly introduce our speakers, and again, I'll introduce both of them following the example of the prior panel, so to, again, save you more introductions by me. Our first speaker will be Florencia Marotta-Wurgler. She's a professor of law at NYU. Florencia serves on the board of directors of the American Law and Economic Association. She is a reporter for the American Law Institute's Restatement of Consumer Contracts. She has testified before the US Senate on consumer matters. She is one of the most influential scholars in the area of consumer contracts. She has done path-breaking work on empirical work on consumer contracts, and she has recently and very prominently and influentially turned her attention now to the analysis of privacy, and in particular privacy policies, which is kind of a major and important subspecies of consumer contracts. Deirdre Mulligan is an associate professor in the School of Information at the UC Berkeley. She is faculty co-director of the Berkeley Center for Law and Technology. She is a principal investigator on the new Hewlett-funded Berkeley Center for Long-Term Cybersecurity. She chaired a series of interdisciplinary visioning workshops on privacy by design. She is a member of the NAS Forum on Cyber Resilience. She's chair of the board of directors of the Center for Democracy and Technology. She's a founding member of the Global Network Initiative, and her work on privacy on the ground is kind of very influential and celebrated. So we have two very accomplished and influential speakers who are going to talk to us about privacy, regulation, markets, and norms, and Florencia is going to kick us off, please.
Thank you very much. Thanks, Oren, for such a kind introduction, and thank you very much for having me, such a terrific event. So the topic of my talk is understanding privacy policies, content, self-regulation, and markets. And so I'll start with a brief bit of background, since many of the findings that I will discuss today relate to US consumer protection in the area of privacy. So for the past 20 years or so, the protection of consumer information online and off has been governed with what has come to be known as a notice and choice model of consumer protection, which is articulated by the Federal Trade Commission. And it has several components. The most prominent one is that it asks that firms adopt privacy policies describing in detail uses of information related to the collection, use, disclosure, and security of information. And the idea, behind most disclosure regimes, is that is for firms to compete on privacy. So consumers will shop around, ideally, among the firms that have the most desirable or the privacy practices that match their needs, and that will induce firms to offer what consumers want. Furthermore, in order to induce firms to offer desirable practices, the Federal Trade Commission issued in a series of guidelines and reports to Congress outlining desirable information practices and urging firms to adopt them. And in order to give it a bit of a boost, it threatened to ask Congress to regulate these firms more directly if they didn't comply with these guidelines, which are entirely self-regulatory. So self-regulation has usually been criticized, rightfully so, for lacking teeth because of its very weak and almost non-existent enforcement mechanisms. So in order to add more strength and to make the regime work, the Federal Trade Commission used its enforcement authority under Section 5 of the FTC Act that allows them to police unfair and deceptive practices and bring actions against firms that violate the terms in their own privacy policies, that engage in deceptive omissions, and also engage in unfair practices. Finally, and most relevant perhaps to this audience, the Federal Trade Commission has been charged, together with the Department of Commerce, to enforce the terms of the US-EU Safe Harbor Agreement, actually now defunct Safe Harbor Agreement, soon maybe to be replaced after all the debate has been settled, with a new privacy shield that would give the FTC a similar role, where the FTC could bring actions against firms that violate the terms of this agreement that allows US firms to bring data from citizens of EU member states. So, although the Federal Trade Commission has had a central role in the privacy area, their regime has been criticized, again, for its very weak enforcement mechanism, and critics saying that it was just not enough for the system or the protection regime to really take off. But lately, there's been a renewed enthusiasm for it, saying that, maybe this system is flexible enough that gives firms enough breathing room to innovate and adapt through norms, and the very strong and persistent work of the Federal Trade Commission has given it enough strength to actually let the system take off the ground, and we have a very good system going on. So what I try to do in this, in the couple of papers that I'll present, is to examine the extent to which, or actually knowing how the FTC model has been working by looking at the content of privacy policy. So some say it's working, some say it's not working so well. We don't know so much because there's been a paucity of systematic evidence in the sense of privacy practices. And it matters because the new proposals rely on self-regulation and co-regulation. So as I said, I focus on two papers. The first paper offers a large sample study of privacy policies to do three things. So first, to give an overview of the current practices as being outlined by firms. Again, the privacy policy is the way in which firms communicate their practices to consumers and regulators in the world. So analyzing that will give us a very good idea of what the practices are. But it also allows us to see the extent to which firms are complying with these regulatory guidelines. To what extent are firms' privacy practices as reflected in these policies shaped by the guidelines? And also, it allows us to explore differences in practices and compliance across markets to get a sense of the extent to which these practices are shaped by differences in markets and in degrees of compliance. The second paper, joined with Dan Svirsky, uses the same sample of policies, but looks at them over a period of time to get a dynamic sense of how these contracts change over time and get a sense of the trends of how information practices, as revealed in privacy policies, change over time. And more specifically, it allows us to examine the relationship between FTC enforcement actions, specifically in the context of the Safe Harbor Agreement, and firm practices, specifically the extent to which they comply with these with the agreement. So after the FTC brings enforcement actions after a firm, what do other firms who also violate the terms of the Safe Harbor Agreement do? So again, the goal is to hopefully inform debates on the Privacy Shield that has a similar role in mind for the Federal Trade Commission. So I'll start with a sample. The sample consists of 261 privacy policies across 7 different markets where there's prominent information sharing. So again, we wanted to focus on markets where people were somewhat aware that they were disclosing information, just to give at least the biggest chance that that consumers might be aware, might be shopping around, and firms might be more sensible or sensitive to privacy. But the level in which consumers might care and the level of information collected varies across markets. So these markets are adult markets, so the cloud computing firms, dating, gaming, news and reviews, social networks, and special interest and message boards. A sample, so the firms are widely representative, from giants like Google and Facebook to very small and obscure sites. Most of them are from very niche markets in the dating world. Surprise, surprise. There's anything you want. There's a flavor for you. If you're a vegetarian or a vegan, here's your particular type of dating site. And we have the Alexa rankings, and which shows the number of users that reflect the number of users for each particular site. Each policy was graded on 49 dimensions, which was noted in one or several prominent guidelines. There's a series of guidelines that recommend the type of practices that firms should outline in their privacy policies. So I basically track a series of them, starting with the OECD, 1973 for information practice principles, and finishing in the 2012 FTC guidelines, which is the ones that we have right now. So we'll start briefly with a description of what do we find in privacy policy. So what the first column in this very tiny print slide says is it tells us the types of terms that we commonly see in privacy policies across 7 different types of categories. So for example, categories that relate to notice and use and privacy by design and security. And what we know is that there's lots of collection, very unlimited and unlimited collection, very few limits on the collection of information, extremely rare disclaimers of collection. Like we won't collect any information at all. That's very rare. Maybe 1 or 2 firms have that. So the collection is rampant. One of the latest efforts of the latest guidelines is to have, we all know that disclosure hasn't been effective in the past. So what we've been trying to do now is to have more effective, smarter, better, simpler disclosures. But it seems that efforts to do so by having shorter or layered or more salient notices haven't really been picked up. The policies are as long as ever, and they're complex, and they're not layered or short or summarized in any particular way. So that doesn't seem to have taken up at all. Second, unsurprisingly, there's lots of sharing of information with third parties and affiliates that are not defined. Again, the arrows show the type of sharing, then the total amount of the extent to which these practices happen, and then the other columns are the extent to which there's compliance with different types of guidelines. But we'll get back into that later. So the third parties with whom information is shared are rarely bound by any type of contract that would impose limits on use or perhaps require some mandatory or minimum protections for the information. So this information is shared rampantly, but there's very little control as to what happens to that information later on. And again, there's very little choice as being expressed in these contracts. And there's a lot more in the paper, but that's basically it. There's lots going on. There's lots of collection, lots of sharing, but and most importantly, and I forgot to skip, for many categories, the contracts just don't say one way or the other. And usually this wouldn't be a problem in some contexts where we have some very well set default rules that will fill in a gap when there's contractual silence. So for example, in a contract that governs the sale of goods in the US, there's Article 2 of the UCC that will fill in a gap if the contract is silent on a particular issue. In the area of privacy, this is a big problem because it's not entirely clear what silence means because there's no default rules. It's not clear whether not saying something allows firms to do something or doesn't allow firms to do something. It changes by context. But most importantly, for the context of the regime that relies on disclosure, when firms don't say one way or the other, it's impossible for consumers to know what the practice of the firm is. It's impossible to infer. So that's a big problem. Now that being said, even if the contract was fully explicit and said everything, you'd still be worried because as we know, at least for some contexts, at least from previous work, joint work, people don't read fine print at all, so especially if it's extremely detailed. So the FTC actually did think of this, and in addition to all of the requirements that I mentioned, it also urged firms and the industry to adopt privacy certifications or seal third-party certifications, where basically consumers would just look at a particular seal or mark and would get a sense of the type of information that is being collected and how it's protected and so forth. The only problem with that is that only a handful of firms have adopted these seals, and about 30% of them have one, but almost all of them, as I said, have to do with safe harbor agreement. The problem with safe harbor, even though it has some requirements, is that, as I will show further later, very few firms have actually embraced the entire requirements of the safe harbor agreement. So compliance is low and it's weak. And finally, there's been initiatives to have machine learning techniques or intermediaries come up with creative and more effective ways of communicating information to consumers, but trust me, from having read a lot of these things, spending summers on this, the contracts are extremely difficult and complicated to read. They're internally contradicting, and it's hard to imagine that machine learning techniques with the current technology can find a way of discernibly figuring out what this what the legal implications of these policies. So now we turn to compliance with the FTC guidelines. So we know what the policies say, but we can also measure the extent to which the policies comply with these guidelines that the FTC wants firms to abide to. So what we have here in the first column is the 7 categories of terms: notice, sharing, user control, security, data practices, enforcement, and privacy by design. The second column tells us the degree to which there is compliance amongst all firms, and the top is overall, and we know that about 39, that firms comply with about 39% of all of the guidelines. Of course, all of these are put together and it's just one big number. There might be some that are more important than others, but I can tell you that the biggest chunk of compliance comes from the easiest or less costly to comply, which is terms that have to do with notice and disclosure. Terms that have to do with the more substantive protections have a much, much lower rate of compliance. So we can see that there's varying degrees of compliance. So for example, privacy by design, that requires that firms adopt practices throughout the firm and throughout the design and the product and service making process are extremely low, just 13%, at least as revealed in the contract. So what the other columns do is it splits the compliance rate by markets, and it reveals some really interesting differences across markets, some of them which are highly intuitive. So as you can see, it has some colors, and what I've done is I've shaded green the practices by category in those markets where compliance is higher than the average firm for all markets. at a degree of statistical significance, and the opposite is true for red. So when you see a red cell, you will see that compliance is lower than average for that market in a statistically significant way. And as you can see, there's a lot of green in the first two columns, and actually the third and fourth columns, and those correspond to adult markets and cloud computing. And specifically, adult markets have very clear notices. The contracts are extremely easy to read. They're short. They're actually great. I mean, they're the best contracts that there are. They should be model contracts. Very little sharing. I don't know if people read them, but they're really written as if people do. They're easy to read. They're easy to follow. And if you think about it, if there's one area, this is, I guess, another idea that I had pre-tenure, but I thought it wouldn't be a good idea to write then, so now I can write about it now, which is, if there's one area I thought where people might actually care a lot. I mean, there's many areas, but if there's one, but it might be visible in something as obscure as a privacy policy that the firm might think about, is an adult site. And we see it. I don't know if people read it, but it's written as it is. So very, very strong notice, extremely careful with not collecting, not sharing anything. And similarly, cloud computing has much stronger security protections than the rest. And the reason why that might be is because a lot of cloud computing firms also rely on the business of getting business from business users that might have lots of sensitive and valuable information, and they might who pay a lot of money for that. So we might see some positive externality to consumers who might get some of this for free. Again, everybody cares a lot about their information of being everybody cares a lot about their information, but they might care especially in terms of their entire information being safe in the cloud. And the other markets, for example, special interest and message boards where people give information sometimes, or they believe anonymously, and they just give some comments about particular things. There's very weaker protections, maybe because there's not much interest in that. Or not, but at least we see some interesting variations across markets in compliance, and then in a table that's not in the paper, in the level of protection of information. So that being said, there's some qualifications here, which is we can only measure what firms say, not what they do. It could be better, it could be worse, but if they deviate too much, firms can get into trouble with not only the Federal Trade Commission, but consumers and state attorney generals. So they can't mislead all that much. And also, if their stated practices are much better than what the contracts say, then maybe it's hard to think of an incentive what they might want to do that. But also, regulators make decisions based on what they see and on what they can see. So this is a unit. This is a tool that we have. Right now, it's always hard to say what the current practices, of course, are optimal. I don't know what's the ideal rate of compliance. I guess we'll hear later in the afternoon about what's the right balance of information collection and sharing and not. But knowing what they are, knowing what current practices are, can certainly help inform policymakers. And finally, it's hard to disentangle variations in policies between the guidelines, market forces, and other factors, but it seems from other analysis that's not in the presentation today that compliance with the guidelines is not a driving factor. It might be other things that might be going on. So now I'll focus very quickly in the few minutes that I have left on the changes of over time paper. So again, what we do is use the previous sample and just take weekly snapshots of the privacy policies, of all of these privacy policies. So this is 251 over the 261. Some technological glitch made us lose 10 contracts from July 2010 to July 2013, and then we have some data from 2014 as well. Each policy is graded on 26 additional dimensions for a total of 75, and many of these dimensions include terms that relate to compliance with Safe Harbor Agreement. The Safe Harbor requires firms to include particular types of terms in their privacy policies, but also to engage in certain practices that we can measure by seeing whether the stated practices in the contract actually comply with those practices. So what we do is we focus on enforcement actions that are brought during the sample period that target safe harbor violations. And we basically do before and after comparisons of the rate of compliance before and after the enforcement action. So and we ask whether firms who are in violation or similar violation of the Safe Harbor Agreement actually revise their contracts in the period after the enforcement actions to see if there's some kind of relationship between those two factors. So we focus on 4 events. I'll just mention them, but basically the first time that the FTC brought a Safe Harbor Agreement violation was against Google in early 2011. And then there's one against MySpace and Facebook around the similar times. We basically used those 3 of them together. And then finally in 2014, there's an action against American Apparel and 13 other firms for a technical violation of the Safe Harbor Agreement, where the firms were targeted for failing to register with the Department of Commerce. So we look and see whether registration has changed after that action. There's a general belief that these enforcement actions are deeply followed and highly followed by firms, and we want to see if this is reflected in the terms of the privacy policies. So here is, again, there's a lot more in the paper, but just to give you a general sense, because this is also new and raw work. So here we have the three events. I mean, don't get too shocked by the flat line. So what we see in the y-axis is the average compliance with the Safe Harbor Agreement. So we see it's a little bit over 60%. And then we look at rate of compliance after the Google event, which is the first line, red line, then the Facebook event, which is the middle red line, and then the MySpace event. And I can tell you, even though you see some minor switches, the line is vertically 0, like the patient is dead, like nothing moves, there's no pulse, there's virtually no movement in terms of however way we measure compliance, and we use several different ways. Just the needle doesn't move any way or another. Sometimes compliance actually goes down. So there doesn't seem to be much movement at all. Again, we can't confer any type of causality with observational data, but this, at least the relationship between the enforcement actions and what we see in the contract is non-existent here. And here is by markets, and again, this is all basically 0, not statistically significant. Finally, we also looked at the changes in rates of change in registration violation, and again, after MySpace, no change at all. But there weren't much violations to begin with there, but they were in terms of complying with a Safe Harbor Agreement. So again, we can't prove a causal connection. There's also some interesting findings that are relevant, because lots of FTC enforcement actions are based on deception. And actions in deception rely most exclusively sometimes on firms' explicit promises. But what we see over the sample period is that firms have actually tended to decrease the number of actionable promises over time, specifically those that have to do with security and data protection. So to the extent that the Federal Trade Commission or states attorneys are using these promises in contracts to bring actions against firms, it's becoming harder and harder because these promises are being diluted over time. In fact, 60% of the terms actually see a dilution over the sample period. Now, there's some slight improvement in terms that had been brought under, I don't know if coincidentally, under unfairness. So for example, practices that were targeted under this prong of the FTC Act have seen some improvements. Firms have stopped using retroactive changes to their contracts and also given indefinite retention period. And also in regards to Snowden, we also see a very significant change after the Snowden revelation. The number of firms that say that they won't share information with the government drops in half. So firms just drop that promise from their contract. So again, some qualifications. I think the one's most relevant for this study is that it's hard to imagine the firms, how generalizable is this? Maybe safe harbor actions are usually tagged along with other actions, and firms are not they're not salient enough. But to the extent that this is a practice that's going to happen going forward, that safe harbor violations are going to be tagged along, we might think of that as informing how the privacy shield might manifest itself, or not, at least just give us a flavor. So just to conclude, it's a large sample analysis of privacy policies with the hope of informing current debates. And what we see so far is that the current regulatory model appears to have relatively limited impact on privacy policies. Compliance with guidelines is modest by any measure. Again, this is as seen it as in privacy policies, little change in compliance after safe harbor enforcement action. So if the real impact is elsewhere, which it might as well be, and we don't know, maybe the focus on the privacy policies is misguided. Maybe we might want to look at something else and make it more visible to the outside world. And market forces may be playing a role, and we can see some intuitive, nice differences in privacy policies across firms. Thank you very much.
Thank you very much, Florencia. Since the presentation was so clear and we did have really many clarifying questions in the first panel, so let's just move on to Deirdre Mulligan, and then we'll take questions at the end. Thank you, Deirdre.
I'm not going to be able to do that. All right. Thank you. It's a real pleasure to be here today. And I am going to be talking about a different kind of empirical work. This is qualitative work as opposed to quantitative work, to give you some different insights of what's actually happening within firms. I'm going to be talking about a study that took much more time. As Florencia said, this sort of work takes a long time than I like to admit. But it was an effort to actually look in an international comparative way at how firms operating in different countries understand and operationalize privacy. The project involved targeted interviews with leading corporate privacy officers, chief privacy officers, CPOs, as we call them in the US, or data protection officers, as they're known more frequently in Europe, as well as key informants. This encompassed about 53, I believe, interviews with DPOs or CPOs in generally what we would think of as like Fortune 500 size firms, so large institutions. And they were identified using a snowball sample, meaning we talked to leading figures in the privacy field. We talked to regulators, we talked to journalists, we talked to advocates, we talked to other data protection and privacy officers, asking them, who do you view as leaders, right? And we were trying to get an insight into what do the best practices look like? What's happening? In addition to talking with these people in semi-structured qualitative interviews, generally for somewhere between 2 and 3 hours at a time, we had follow-up interviews, we sent them questionnaires, we looked at organizational charts, we looked at policies and procedures where we could, we looked at training materials. Sometimes we got to talk to technical people, people lower down in the food chain, depending upon the organization. Given that this is qualitative, kind of what we think about as grounded theory, right? This is like literally starting from the bottom up, trying to understand what's happening inside firms. And given the sort of organizations we were looking at, right, this is like the organizations that are more likely to be responsive to shifts in the regulatory environment, to consumer concerns and other sorts of things that influence firms that feel like they have big targets on their backs, right? These are large institutions. Thinking about the extent to which these findings are generalizable, right, down to small or medium-sized enterprises, you have to be really cautious, right? And for many reasons, I think that these give you a good sense of how regulatory and other sorts of external influences shape corporate behavior. I don't think that you're going to find these particular structures if we drill down deeply in any economy in which we looked. The countries where we conducted interviews you can see up on the board. I don't really need to tell you which countries they represent in this international kind of environment. And I'm going to discuss the findings and policy implications in 3 parts. One, I'm going to talk about an emerging suite of best practices among industry leaders. 2, I'm going to talk about properties of the privacy field, right? So this is the regulatory environment plus other elements in different jurisdictions that seem to catalyze these best practices. And finally, I'm going to close with some thoughts on recommendations for policy reform. So the best practices, we talk about bringing the outside in, and they emerged as making the board's agenda. So this was a high level of attention, resources, access, and prominence for the privacy function within the firm. This generally meant that in some firms, we found privacy leaders who were not part of the compliance function. They were not tethered, for example, to legal and corporate affairs. They were not purely tethered to risk management. These folks tended to be people who affected strategic decision-making within the firm. They had access to the board. They were in a position where they were a participant in strategic organizations. That meant they could affect things not just about what does it mean to comply with the law, but what were the risks, not just legal risks, but kind of broader if we think about social license or business relationship risks of entering a market or engaging in a particular practice. 2, a boundary-spanning privacy professional. All of the organizations that we identified with these kind of best practices had a high-status privacy lead whose responsibility was not purely internal, that they spent at least 50% of their time mediating between external privacy demands and internal corporate privacy practices. What that meant, they were in many ways kind of the ambassador for the outside world. They were in the interpretive role. They spent time both with their peers and other corporate privacy or data protection officers, but with regulators, with civil society, with workers' councils, with political parties, trying to understand what were the privacy mandates that the outside world were placing on them, and how could they actually translate them into firm practice. So this was very much a boundary-spanning role, not a purely internal compliance-oriented function. Finally, what we term the managerialization of privacy. This is reflected in the integration of decision-making on privacy issues into things like technology design, business line processes, through the distribution of privacy expertise within business units, assignment of specialized privacy staff to data-intensive processes and systems, and in a very specific way, it meant that privacy was moving out of the legal shop and onto the shop floor. So why are these practices valuable, right? Why did we identify these practices as things that were best, right? Best in class? Well, based on existing literature, some in organizational behavior and decision-making research that looks at the value of distribution versus siloed functions, right? So as we distribute responsibility for values and we build accountability in, right? The same way you're responsible for productivity, you're responsible for compliance with environmental laws or with compliance with privacy. As we distribute those responsibilities out and hold people in kind of line item business units responsible for them, we get greater translation of policy into practice. 2, empowering internal actors within organizations is often accomplished by tethering them to external communities that validate different ways of evaluating firm practice. Right? So it's not just about making shareholders happy with return on investment, right? That these separate kinds of professional communities or separate forms of regulatory communities create an additional framework through which corporations begin to understand their obligations in the world. And in that tethering, we empower the people who are responsible for that activity. Finally, tools and technologies and decision-making are a really important component of enabling distributed expertise and accountability in a meaningful way. Finally, from privacy research, as many of you know, right, the General Data Protection Regulation has a requirement for privacy by design, as Florencia was mentioning. Regulators across the globe the International Data Protection Commissioners Conference several years ago kind of signed on to a commitment to try to push privacy into technical design. There's work in the European Union, there's work in the US involving the technical community. This includes engineers and designers, people who are not practitioners of law, but people who are trying to actually make values tangible, right? The way in which we bring things to life in practical systems so that privacy can move from something that looks like legal process to something that is more about intuitive practice and functionality of technical systems. If we want to do this, regulatory strategies that move privacy outside of the legal sphere and actually push them out into the business units and out into technical design are essential, right? It's not just good privacy, it's where privacy. And finally, there's value in this sort of distribution of privacy expertise, richer professionalization within firms, as we understand that privacy threats may not be just from the firm behavior themselves, but from external actors who are seeking access to data and information that firms have, often in ways that are not checked by the data protection authorities, for example, or the courts that we think about as in an ideal world functioning to protect our privacy, that greater institutionalization of commitment to privacy protection within corporations may have value exactly as the threats to privacy are perceived not just as from corporations, but from these other external actors, for example, governments. So where were these best practices present? As I mentioned, we studied 5 different countries, right? France, Germany, Spain, the US, the UK. Germany. So despite very different legal rules, right, formal law, and governance models, and importantly definitions, right, what do firms believe privacy means, the US and Germany were the locus. They were where we saw these richer institutionalization of privacy emerge. I want to point out, because I think we're very familiar with the different legal rules and the different governance models, although I'm going to highlight some of the choices that are important later on in my presentation. But I right here wanted to highlight some differences in definitions. In the US, and so we went in to talk to people. There were these people who were doing privacy work or doing data protection work who often still think of themselves not just as data protection officers, but actually as protecting privacy within corporate actions. And what did they actually think they were being charged to do, right? Their privacy, it's a very ambiguous and capacious term. What is it that they thought they were mandated to be responsible for? And what did organizations actually view? As we were interviewing these chief privacy officers and data protection officers, not because we cared about their thinking per se, but they were a window into the firm, right? They were a way to understand the firm. And in the US, there was a very limited role of compliance, right? And Florencia was just talking about the guidelines from the Federal Trade Commission. You know, note, those are guidelines, right? Those are not law, they're not even self-regulation, right? That they are not co-regulation, they are guidance. There was a very limited role on compliance per se. Now that doesn't mean that there was not an attention to various forms of formal and soft law, right, hard and soft law. In fact, the OECD guidelines and the European Union's Data Protection Directive, even in the US, were prized for providing some clarity about kind of overarching principles that expressed privacy commitments. However, they were viewed as insufficient in some ways, and for one, they were not sufficient to help firms manage risk, that they could view themselves as being compliant in some ways and still find that there was something that happened that exposed them to risk. And more importantly, with the advent of different sorts of technologies, so sensing technologies, here you often call them ambient technologies, the Internet of Things, machine learning, there was this broader understanding that actually addressing the consumer interest in privacy required them to anticipate expectations and avoid being creepy, not just follow a set of rules. The German leaders' definitions of privacy were interesting in that Yes, compliance played a role. Clearly, German formal law, right, was very important. However, that data protection framework was nested in a broader set of ethical frameworks that are around the dignity of the individual, very much coming out of the horrors of the Nazi era. People were very concerned about data, not as information, but data as a component of respect for data as a respect for human dignity, right? And a different attention to data protection as a human right, right? Coming out of your constitutional tradition, et cetera. In addition, data protection was linked to the social interests and ethical obligations around workers' rights. And this, in part, I'm going to talk about as the kind of very important kind of co-governance model that is typical here in Germany. So is this a new privacy paradox, right? We see these two countries with very disparate formal law, very disparate governance structures, yet underneath those emerging very similar institutional structures to manage what they perceive to be their obligations. And what we said was, when we looked at this, we said, no, we just need a new analytic framework. But people have been very focused on what the law, what the formal law does, and what organizations, do you have an independent data protection authority or do you not? And instead of focusing on the presence or absence of those specific actors or institutions, if we readjusted our lens and we actually considered the functional roles and interactions, there were some common and roles and interactions that had been identified as critical to the development of both fields by our cohort of interviewees. And they could be performed and supported by different actors and institutions, yet seem to somehow or other catalyze these similar practices. So what were some of those key properties of the regulatory field? One, we found ambiguity with accountability. So what does this mean? An earlier study in 1995 by H. Jeff Smith had basically he had looked at 7 corporations in the US and dug very deeply into corporate practice and policy. And he basically had come away saying that privacy had been kind of orphaned within the corporate infrastructure, and that it had been policies wandered around. There was a reactive policy cycle. There'd be some external shock, and people would kind of scramble to do something. But no one wanted to be responsible for privacy because it was such an ambiguous task, and therefore nobody who wanted to kind of climb up the corporate ladder wanted anything to do with it, right? Like if you want to succeed, you want to know what the test is, right? And so privacy was this thing that didn't have a lot of clear direction. And so within the US firm, he said nobody wants to manage this, so it's this orphan issue. And that until there was a reduction in ambiguity and some clarity about obligations, privacy within the US field would continue to kind of lie in a very weak state. Well, we actually found something quite different. And what in both Germany and the US, and I'm going to explain why, we found that more open regulatory approaches and broader legal mandates combined with accountability, right? So ambiguity of a sort that we're going to talk about as being productive, when combined with activist regulators and meaningful stakeholder scrutiny, could foster dynamism in the face of changes and to push more accountability into firms so that ambiguity wasn't necessarily the problem, but a lack of accountability was a huge problem if you coupled it with ambiguity. Secondly, we found boundary-spanning communities. So the privacy leads in both Germany and the US situated themselves in a broad and inclusive community of outside stakeholders, including other corporate privacy professionals, those from civil society and government, who both challenged the inside privacy officers and empowered their role in the firm. Germany, from the very start, has had a professional association that has provided training and leadership and development for data protection officers, as long as there's been a requirement for them to be data protection officers. In the US, we saw a growth in what's called the International Association of Privacy Professionals, but had earlier iterations, so broad professional communities. But those professional communities were not just closed off to corporate professionals. They involve, in the German instance, lots of interactions with regulators and political parties, workers and churches and other institutions that are thought to be spokespersons for civil society. And in the United States, much more of a focus on advocacy organizations and regulators than other aspects of civil society. Finally, the last key property was disciplinary transparency. And transparency has been, as I think Florencia was trying to emphasize, it's kind of a panacea, right? And then Alessandro suggested this too. Well, it's that easy thing where we can say, well, just let people know what you're doing. And the European Union Data Protection Directive has always required certain kinds of transparency, right? The transparency of registration, the transparency of licensing, the transparency of making your processes, sharing information about what you're collecting and your processes, et cetera. That isn't the kind of transparency that we're talking about here, right? This is about privacy failures. This is transparency that's prompted by things like data breach laws that require companies to report that they've messed up, or penalties, large penalties levied by regulators that create a level of transparency around privacy failures that get the attention of the board of directors, of shareholders, of the broader public, and also enable individuals and institutions other than regulators to be part of the enforcement and feedback loop. So this is a different kind of transparency. So what were some of the key properties at play in the US and Germany? So first, in the US, we saw this emergence of a network of norms. The Federal Trade Commission, which Florencia has mentioned, looking at policies, but again, the FTC has only in some limited areas, right? So with respect to children's privacy, with respect to the Fair Credit Reporting Act, right? With some small sectors, actual regulatory authority, right? The ability to write rules and enforce them. For the most part, much of the FTC's privacy work has been carried out through enforcement actions under their Unfair and Deceptive Practices Act. And as Florencia noted, early cases really focused on affirmative misstatements, but there are also cases that are about omissions, right? So if you don't provide information that is material, right, as in consumers might have made a different decision, but for that information you've withheld, or things that are just fundamentally unfair, right, that they put consumers in harm's way in a way in which is unavoidable by them and really doesn't have any benefit. So the Federal Trade Commission, those enforcement actions were important. However, there are a whole suite of other activities that are grouped in kind of legal literature and governance literature under the concept of new governance that involve stakeholder consultation, hearings and workshops, dragging industry in to talk about how they're using RFID or using beacons in stores or how they're using video monitors to look at individuals. They created an opportunity for advocacy organizations, the media, and other stakeholders to critique and weigh in on and actually participate in framing both privacy's meaning and what sorts of obligations firms should have, or where the no-go zones were. Additional changes in the US landscape that were viewed as very important were the creation of the state data breach laws. And these were important, again, because they made privacy failures visible in a way in which were kind of very present and impactful on the board of directors. And all of a sudden, privacy was something that the board cared about, and that helped shift it from something that was kind of a compliance function, something that lawyers dealt with, to something that was viewed as having the potential for reputational risk, right? It could cause churn, it could cause risk in shareholders, it could cause risk with business partners, et cetera. In Germany, we saw a different set of organizations that played into this creation of the nested norms and the negotiation of privacy's meaning. Unlike the US, where a lot of this kind of negotiation around privacy's meaning to sort out ambiguity, which empowered these other stakeholders, this was happening inside German firms. And Part of that is because of the role of the data protection officer, which is an independent officer, right, within the German firm that reports directly to the CEO, but also reports to the regulator and consults with the regulator. But it also, another internal issue that was very important was the independent role of the Works Council. And the Works Council has the ability to influence all decisions around surveillance or data collection activities that implicate workers' rights. And they too played a very important role in bringing the external perspective of privacy into firm negotiations and considerations in a way in which helped policy translate in a more meaningful way into practice. So what sort of regulatory reforms might help bring the outside in, right, if these are the goals? Well, one of our conclusions was that encouraging and empowering professional communities and professionals within firms is a really important factor. So we didn't go into our research looking to study chief privacy officers or data protection officers. We went in to talk to them to understand firm behavior. We left understanding that Germany had made a very important strategic choice in their data protection governance framework by deciding that rather than having regulators dictate in kind of tiny rules what firms ought to do, that firms were required to invest in individuals who would do that interpretive work. And that those individuals were going to have access to the sort of information about practices and policies and business units and technical design that no regulator could possibly have on a day-to-day basis. That decision to turn to professionals was a really important regulatory choice. So in the US, we ended up with that in a much more haphazard way, right? It was partially because of initial negotiations around the Safe Harbor Agreement, which required firms, if they wanted to participate, to have somebody who was responsible for privacy. Eventually, we had an emergence of this chief privacy officer role, and you could say, well, maybe part of this is, just everybody trying to look the same. But it turns out that these people ended up being strategic players, bringing a different lens into the firm other than just the kind of lens of the bottom line, and continuing to maintain that separate lens in firm practice is important. Meaningful transparency is really important. Lots of disclosures, I think we all agree, basically end up burying consumers with lots of unactionable information. They often have no choices, right? The privacy practices of most institutions, I would suggest, the economists in the room, you can all critique me, but I would suggest it's a credence good, right? The companies make lots of statements about what they're going to do, and consumers have a difficult time judging them on the front end. They can't really judge them through experience because there's no promise that they actually understand what's happening behind the scenes. Are you sharing information with the government or not? I have no ability to know, even after I've experienced your practices. So there's a high degree of inability to understand what's happening to begin with, right? It's only experts who can actually understand, or regulators with expertise. Utilizing regulatory processes that engage firms and other stakeholders in defining privacy norms and making the rules that promote those norms is essential. So in other countries where the only dialogue, you could look in France or in Spain, is between the regulated and the regulator, privacy is not this dynamic concept. It tends to get narrowed and whittled down to data protection. If we want robust, more lively definitions of privacy, there has to be room for civil society, for workers, for political parties to participate in the negotiation of privacy's meaning and privacy as practice. And finally, we need to actually exploit the market and advocacy capacities to develop collective understandings of risks and solutions to future privacy problems. All of these practices make firms more permeable to external demands. They make firms more vulnerable to external pressure. And they enhance the authority and available resources and independence of the boundary-spanning corporate privacy and data protection officers, who I believe we need to move privacy forward. Because we're almost out of time, well, let me give this last one. Things to try not to do. pursuing regulatory coherence and uniformity was not necessarily the best outcome, right? To the extent that there are tightly prescribed rules, you can have, as we found in France, a relatively low-level lawyer who receives them and transmits them to the firm, right? If you have less specificity about what's required and you make firms participate in understanding and going through the hard work of understanding what privacy means for their businesses, you will get more engagement. You will get more investment in professionals. You will get deeper penetration into the firm. So focusing on the development of government agencies as the primary locus of professional expertise risks having great expertise on the outside and very little ability to translate it into practice on the inside. So this rule-bound governance can diminish corporate reliance on high-level internal privacy experts and in turn reduce the professional's capacity to embed privacy into corporate culture and business operations. So given that I'm kind of highlighting some of the importance of professionalization as a regulatory strategy or a governance strategy, I do just want to note some of the challenges. So when we think about professionals, we often think about two different kinds. One are professionals who bring a certain kind of expertise, right? So an engineer is usually hired not because they bring a separate way of looking at the world, but because they can advance the firm's interests with their detailed expertise about formal specifications or whatever it might be. Other forms of experts we bring in, we view them as important not just for their expertise, but actually for the separate way in which they evaluate progress or success. And data protection officers in Germany, in part because they are statutorily created and independent, right? They can maintain a level of independence and have their own separate yardstick for measuring what firms ought to aspire to. Chief privacy officers in the US, they don't have that same independence created in a statutory way, right? What they have cultivated is a community of like-minded individuals to whom they feel somewhat tethered and responsible, whose metric for success is not consistent with pursuing everything along the corporate bottom line's interest. So one question for the regulatory enterprise is how do we maintain professionals that are both experts as well as people who bring the separate lens that import civil society, public values into firm processes in ways that are meaningful and sustainable. And with that, I'm just going to note that my co-author on the book is Professor Ken Bamberger at the Berkeley School of Law, and thank you for your time and attention.
So thank you very much, Deirdre. If I may just kind of open with what I think is a clarifying question for Deirdre, just following up on this excellent presentation. So one of the main themes that you emphasized is bringing the outside in and kind of the CPO or this high-level privacy officer kind of tapping into these external privacy demands. And I was trying to if you could help me be a little bit clear about what these demands are. So you were mentioning civil society and other data professionals and bringing these norms into. And one thing that was very clearly not there, at least not directly, was the consumers, the clients of the firms themselves. And I was wondering, is that because of the reasons that we were discussing in the first panel, or maybe for other reasons? And just another aspect of this, another thing that you mentioned is that we want to push privacy from the legal to the business. That was one of the things that you mentioned. Again, so the external thing that we're bringing in is not the regulation, it's not the law, it's something else. But when you're talking about the business, doesn't that have to take into account consumers? Or maybe there's some other way to do that?
Yeah, this is on. I first want to tackle your first question about just about bringing the outside in the first question. And I want to highlight something that we found really, really interesting. Right? So Germany, made a commitment to have this, to use professionals as part of their regulatory strategy early on. And so there was the creation of a requirement for a data protection officer. For some firms, those are external firms. For the ones that we interviewed, generally they were I think exclusively, they were internally situated people. One of the things that was most interesting is that despite the fact that they're independent, they're required to be provided with resources and the capacity to engage in training, and they've had a professional association since the very beginning that helped them kind of organize and figure out what it was they were supposed to do. It wasn't until much more recently, with the reforms in 2001 and 2007 that happened in federal German data protection law, that those people became the strategic actors they are today. And why? Because those reforms did several things. One, they gave new powers to German data protection regulators. Those included both greater investigatory powers, right, to demand and look at documentation, much greater fining capacity, right? So when we talked about ambiguity coupled with accountability, it provided that accountability hook that had been in many ways lacking in German law. And then second, in 2007, on the wake of the Deutsche Bahn and the Deutsche Telekom, you know, massive privacy scandals that really every single data protection officer and informant that we spoke with mentioned these scandals as having a very serious impact on the way in which corporations viewed privacy in connection to kind of firm standing in the community. We saw the adoption of the security breach notification laws here in Germany, and those created, in this disciplinary transparency loop, a way in which, as breaches became public, the Works Council actually became a really important conduit, because most of those breaches affected the public, including the workers, right? And so the Works Council became more kind of vocal and more kind of effective as colleagues with the data protection officers, in part because they were fueled by this greater transparency, this kind of a disciplinary transparency around privacy failures that ignited a more public conversation, right? Certainly a political conversation, but a conversation among consumers, et cetera, that brought privacy back inside in different ways. So it was, in the US, there's a focus on consumers, avoiding being creepy, trying to be consistent with expectations, lots of attention to the friends and family test. How does this look if it's on the front page of the Wall Street Journal or the New York Times? In Germany, you know, no, consumers do not really do, the conversation was not in any way centered around consumers or consumer protection. It's focused around data protection, human rights, dignity, really not about consumers, to the extent that privacy came up in the market context, much more about business-to-business relationships and not being able to peer or partner with organizations if you were viewed as a laggard. So really consumers, particularly in Germany, not qua consumers, but consumers as citizens, for sure.
Questions from the audience? In the back?
Thank you. Christoph Busch, University of Osnabrück. I have a question for Florencia regarding the role of machine learning or automated processing of privacy policies. You mentioned that so far machine learning techniques are hard to implement due to internal contradictions and inconsistencies in the writing. The reason why privacy policies are difficult to read by machines is probably that they are written for humans. But if the humans don't read these texts, wouldn't it be better to write the text for machines in the first place? That might make it possible to run some sort of automated processing and exercise a grading, probably along the 49 dimensions you used for your study, and calculate on that basis a consolidated privacy score, which could then be disclosed to consumers, just like the annual percentage rate in consumer credit contracts. So higher salience, less information, could that be a way forward?
That's a very intriguing point. So somebody has suggested to me to engage in that particular endeavor, and I know there are other academics. I know Alessandra is part of it as well. Alessandra is part of a team putting together a machine learning approach, trying to do just this. And in fact, there's a paper that talks about all the even among experts, the internal contradictions and impossibilities of agreement about the meaning of a particular term, not even imagine the legal meaning of a particular term. So if the contract is written, or if regulators require firms to write contracts in particular ways. So for example, there's a really interesting study by Laurie Craner and a co-author about the degree to which firms comply with a Gramm-Leach-Bliley Act, that is the act that regulates disclosures by firms that engage with financial information. There's a form that firms can choose to complete, and it's really just like a fill-in-the-blanks thing, and it's a very easy way of digitizing. So that would be an approach. So that's certainly something that could be done. The question then, which I think that's a relatively easier question once you solve the ambiguities. I think the harder question, at least for me, and this involves the work that Alessandra is doing, is how do you weigh each term, right? You have 75 plus terms. Now, some might be relevant, some might less so. And so for the score to be meaningful, it has to say something about what people care about the most. And because it's hard to elicit that information, I've shied away. I've shied away from that, but that doesn't mean that having something that's not perfect but better than what we have now is not a noble endeavor. And I think it's being done. And maybe Alessandro can talk more about that, because he's as I said, he's doing, I think it's an NSF grant, right? Yeah, a big NSF grant working on this. So yes, it's being done, and I'm happy to contribute my terms if that helps.
So I actually had the honor of presenting what was then called, it was a concept, the Platform for Privacy Preferences, with Tim Berners-Lee, who was the head of the World Wide Web Consortium, at one of the very first Federal Trade Commission hearings about privacy, workshops on privacy, right? It was a novel idea then, right? We were going to use metadata about websites to actually reduce the transaction costs that consumers face, because your user agent, for all of you in the room, your browser, would be able to look and see what the privacy policy, what data elements were being collected, how the data was going to be used, all in a standard language with standard data types, standard uses, etc. And it actually, emerged as a standard. It has been rarely used. There's an implementation by Microsoft. I'm not sure which browsers it's in, etc. Some companies actually made their privacy policies available in XML, so you could actually use your browser to parse them, but many didn't, and there's lots of reasons why. So one, even the push, right, so Florencia said nobody's using short notices. How many people in this room are lawyers? Okay, so when you make a short notice and you make a long notice and there's any inconsistency between the two, how do you feel? Vulnerable, right? I mean, this is right. So there's been huge resistance unless there's kind of clear standardization. You can look in the US to something like the Schumer box, where there's agreed upon, right? Everybody knows APR. We all know what that means, right? Or there are certain things, like we have an understanding of what things we're going to disclose. When it comes to uses of information, people often want to say, we may disclose your information, right? Technical systems, no, I want a yes or I want a no. I don't have any room for may. The amount of time I spent in the W3C arguing that you could not, in fact, have a may, you don't even want to know, right? What does it mean to track? What does it mean to create a profile? What is it, right? Like, all of these terms have to be standardized and defined. So the barriers, if we're thinking about collaborative filtering, right, participating in a way that would reduce the transaction costs for consumers and firms to, quote unquote, negotiate around data practices, for consumers to engage in voice and exit and all those things, they are not technical barriers, right? There is a lack of will to actually standardize a vocabulary in order to make those sorts of decisions meaningful. And you can look at the Do Not Track working group at W3C, which suffered from the same sorts of issues. I think that regulators could put far greater pressure on industries to standardize terms and use terms in consistent ways. But I also have to admit that the problem starts with us, right? The people who draft laws, so I would also point you to work by Travis Bro and Annie Anton, who are really excellent requirements engineers that have looked at some of the complexities of trying to elicit requirements for technical systems from legal text. And when you look at any one of these contracts, not only are they written in verbose legal language, most of them, they also reference 15 other forms of law that you have to go and look at, and background rules, etc. And so it becomes really, really difficult if you want to use, as Carnegie Mellon is trying to do, natural language processing to make sense of this so that you don't need the cooperation of the other party. And so I'm very hopeful that the Carnegie Mellon team will make progress, but I also think that it shouldn't be that hard.
Gerhard Wagner.
Yes, I have found Deirdre Mulligan's approach very fascinating, because usually in economic analysis one treats an enterprise like an individual. So you direct incentives towards the enterprise and you imagine that they will behave rationally, avoid sanctions that are more costly than the benefits they reap from illegal or unethical behavior. And in fact, we all know that this is not the case. There are many actors inside the enterprise, and they have not the same incentives and not the same perspective as an individual would have if it were an enterprise. So very interesting, I think, and it also showed how complicated matters can be when you sort of drill up this issue and see that there are many actors. Now, regarding the institution of the data protection officer, I wanted to add a little bit more context. One is that German corporate law never subscribed to the shareholder value approach, but always operated with a set of stakeholders that most prominently included workers and their works councils, but not only. And there is a crucial difference to American corporate law, that the workers are represented not only on a plant basis, but also on the board. So they sit on the board, they listen to what is discussed there, and that helps them a lot with regard to knowing what goes on and why policies are shaped in a certain way. This policy tool was first, the idea to supplement that by a special purpose officer was first developed in the 1970s in environmental law. And there is a lot of research how these people behaved and whether they generated a lot benefits or to what extent they did so. And as you said correctly, the idea was to economize on enforcement costs by sort of implementing a regulator inside the enterprise and making that person personally accountable for what goes on in the enterprise. And that worked to some extent. These people usually complain of some schizophrenic problems they have. On one hand, they're employees of the enterprise, and they have to, of course, follow the policies implemented by the board. But on the other hand, they have sort of a countervailing purpose. They must set limits to corporate policies, and that may be very, very difficult if you have, set your limits for your own employer. And as you correctly noted, I think it works best and better in data protection law than in environmental contexts if the interests of this officer are aligned with the interests of the workers. And there is a substantial overlap in data protection between interests of workers and interests of data protection officers. They both have similar concerns. However, as Oren noted at the beginning of our discussion, I think it's a little different with consumers. Here, as environmental law also, oftentimes the interests of the workers and of the board are identical. Workers want to keep their jobs and drive up wages. The board wants to increase output and revenues. So they don't care much whether that places externalities on the environment or on third parties. And I guess it's similar in the data protection area. These scandals you correctly noted were all about workers' data. And so I imagine that changed corporate policies a lot, and that their workers' councils and their representatives on the board got very active. Whether this whole setting, this amalgam of workers and data protection officers is so great when it comes to protect the interests of outside parties, who, if they are successfully protected, may cut back on wages and profits. I'm not so sure about. I would agree that the attempt to get to some self-regulation in the area of data protection is a good idea, and is certainly a nice supplement of heavy-handed government regulation, but it's not a sure thing. It doesn't work like a perpetuum mobile. It needs some additional safeguards and incentives to make it really work in the interest of people outside the enterprise. Thanks.
So I just want to pick up on one thing that you identified, which comes out very strongly in the US and Germany, and it also, Ken and I did an earlier study looking at privacy decision-making in federal agencies, comparing our State Department with our Department of Homeland Security. And this issue of the relative independence and impact of the privacy lead or data protection lead. And for every person that we spoke to, right, this is a very complicated dance. On the one hand, privacy has to, right, if we care about it, be a strategic issue within firms. It has to be able to participate in the level of market entry or product design, or, you know, ought we to buy this company, or right, it has to operate at the strategic level. However, on the day-to-day, it has to function as a requirement like any other, because it has to not be consistently viewed as a political debate every time you want to build something into a system. And so this dance between maintaining privacy as a high-level strategic issue and embedding privacy in day-to-day processes in a way that was depoliticized and stable was one that was struggled with in Germany and in the US. In the US, it's accomplished through the use of many indirect reports and embedded people, right? And so they do a lot to train people who are otherwise, you know, you're a software engineer, but you have special training on privacy. So when you're developing a product, you're not viewed as the lawyer coming in or some privacy nerd. You're viewed as like a legitimate person who's supposed to be there, who just also happens to have this additional expertise that is legitimate, right? Because it's part of our day-to-day work. In Germany, in part because of the independence, right, requirement of the data protection officer, there's much more of a focus on dedicated employees, and so there's some challenges in kind of embedding them in the same way, but you do get a greater degree of kind of independence. But in both countries, there was a real kind of struggle between how to maintain that strategic impact and also really be in the kind of, you know, mix in operational practice. And so you're right to kind of hit that issue. I think it's one that we need to think a lot about. And I think environmental law can teach us lots of things, and I think this is also an issue that they've struggled with. Board attention, because it turns something into risk, not just compliance, ensures that people need to be attentive to it, right? You manage what you measure, right? And it provides a different level of incentive to build out practices.
Other questions? Amelia.
Thanks. Two really interesting talks. You both, you gave rather different tones to your talk. So I'd say Florencia seemed a little more downbeat about the situation. Deirdre seemed a little more upbeat. But you both essentially said that the practice within firms may not be visible by looking at the laws or indeed the contracts. that are there, but actually you need to see what they're actually doing in respect of consumers. And I'm sure that must be right. But in that context, Florencia also put up these incredibly crisp figures about compliance with FTC 2012. And I just was left really unclear about whether 37%, I think it was, average compliance as a whole. Should we be worried?
That's $1 million question. I don't know if we should be worried or not. That's a much harder question. That's why we focused on compliance. And I wish Julie Brill was here to give us a sense of whether we should be worried or not. But to the extent, if we assume that compliance with those guidelines is something that's desirable, and it's something that the firm should aspire to do, the White House came up with a consumer privacy bill of rights that basically mimicked many of the guidelines, and it said that it urged firms to engage in self-regulation to adopt these guidelines. Now, whether that's the case or not, whether that's something that is desirable or not, whether that's something that's going to deter innovation and hurts us in the future is something that we don't know. I think we'll know a lot more this afternoon. But to the extent that, assuming that that's the case, then the weak level of compliance is problematic. Now, whether the results that I presented can speak much to that, unfortunately, it cannot. But it can help inform, hopefully, I'm hoping, since it took a lot of work to do, I think it can help inform the debate to actually now have a benchmark. Well, this is what's going on. This is how the practices are. This is how there's compliance. And this is the relationship between some enforcement actions. I mean, not all. I mean, as Deirdre said, there's some that relate on unfairness. It's a very small number because you need to prove a lot more. You need to prove substantial harm that survives a cost-benefit analysis that it's very hard to do. So the big core has been focused on deception, and so the question is, whether the enforcement actions are doing much. I have a teeny tiny evidence that shows, at least in the context that I saw, it doesn't, the needle doesn't seem to be moving. That doesn't mean to say that there might be other factors or other forces that might be offering, the types of information practices that consumers want or don't want. But to the extent of, by looking at the particular lens of the compliance with the guidelines, assuming that that's a normative desire, and that's, a big if, and I won't put anything on that, then it doesn't seem to be the case. But to answer your question, I really don't know.
So I'll add some more. If you talk to lawyers who advise companies in the US, if you talk to regulators, if you talk to privacy advocates, they will all tell you that the activities of the FTC have been responsible for many changes in the way in which corporations behave. Enforcement actions have not focused, right, the FTC doesn't have authority to require people to provide notices of anything at all. Right? And so while Florencia's examination looking at whether or not enforcement actions triggered changes in notices and finding that there were not changes in notices, while it may seem shocking to you, it does not seem that shocking to me. I think that firms look at what were the practices that got people in trouble, and then they may modify their practices to address those. To the extent that those are things that might show up in notices, you might see them, but I think one would need to look at the specific enforcement actions and to say, and to some extent, and I have read Florencia's, at least one of her papers, but I think there may be more forthcoming that I think she may talk more about. But there are particular things where I think you could say, the fact that security disclosures have gone down, I think, the FTC has basically established at this point, right, if you are collecting personal information and you're not handling it for sensitive information, financial information, information about health, in a way that, like, you're not providing kind of some baseline of security, it doesn't matter whether or not you've said anything about it, right? Or if you said, give us your health information, we're going to provide you with absolutely no security. Like that wouldn't fly, right? That would be considered, that would be a great grounds for an unfairness sort of action, right? I don't necessarily think it requires a disclosure of any sort. But to the extent that firms make specific statements, it creates specific sorts of bullseyes, right? And so the fact that firms may be whittling back on the specificity of their disclosures may in fact reflect the fact that the FTC doesn't enforce them, and therefore they don't want to make specific promises. They want to make more general statements. They don't want to promise a particular form of encryption. They don't, right? So that there's some bizarre relationship between disclosures and enforcement actions. And I too would welcome, Julie's thoughts on them. But
One quick remark. So whereas it's true that many or several FTC enforcement actions focus on behavior, actually the enforcement actions that relate to safe harbor indeed focus on notices in the contract, because that's what you need to do to comply with the agreement. So that's directly measurable by the contract, and you still see no change. So the findings are relevant in that context. So yes, it's mildly depressing, but maybe not so. Yeah.
So I want to thank our panelists, Florencia and Deirdre. Thank you for a great panel, and I guess now we have lunch.